Pretty with TBR.
We'll get started, folks, if everybody's ready to go, and Judy's gonna update us.
Boy,
on where
there's
we
a
are.
lot of trouble.
Good morning, everybody. In case you didn't pick them up, there are materials on the back table, including the agenda. The green sheet is the proposed revision that Molly has for the legal notice section. And hopefully, I sent it to you, I sent everything in a PDF, so if you printed it out, hopefully it's the same pagination and line numbering as what we have, but if not, the green version is Molly's proposed language. Then the blue pages that are in the back are all the changes that have been made since day one that we've worked on this up through September, so in case you want to just keep track of all the strikeouts and underlines. That one was getting to be really hard to follow because of so many strikeouts and underlines, and I started getting lost, so I thought, okay, we'll just stop there with that one, keep this one as a institutional memory. And today we're going to start working on the white document that's in the back. On the front it actually has the judicial branch logo, so we can start to know which version is which. So starting today, we'll start using this one and go forward for a few months and see how marked up that one gets. And then eventually we might go to the next version. So the one that I'm calling the clean version is the one that we're working on today. It incorporates all the changes that we've made so far. Any comments or notes that we need to double back on are on the last couple of pages. So you'll see when we get to the very end, there are some notes to ourselves about things that we need to double back on. And then the one document that you have not received and is not with us in the room today is the child development section.
That'd be my fault.
Judge Charnowski and Pam both did a wonderful job of working on the same section of the child development. And so we're going to try and work
But you
through.
did get Pam's probably, because you mailed it to everybody, did you?
No,
Oh,
I
just to
mailed
us?
it to.
Oh, I was thinking that you did come to everybody.
No. So we'll probably, not probably, we'll mail that out, the child development section before the next meeting, and we'll work on that at that meeting. In between now and then, we'll just finish that section and go from there.
So we're doing other sections today?
So today, we'll be starting with section 4, the new numbered section 4, which is on page 15 of the clean version of your document. And maybe the other thing I would say about the child development piece is when Pam sent hers, she wrote much of hers in prose, so it's more like paragraphs. And Judge Charnowski went through it and, not knowing that that was what Pam had done, made it into bullet points. So throughout the day today, I'm going to put 4 copies over on the table. And maybe you could look at just the first few pages and let us know your preference. So when we do the next version, do you like it in prose or do you like it in bullet points?
So can you remind me, refresh my memory what they're doing? That's just regarding the introduction.
No, it was just it was the child development, because remember it was not
It
organized.
was 0 to 10.
Okay.
Yeah, and so we both ended up doing 0 to 10.
Okay.
Even though I said I would do 10.
So everything, so all the ages and stages of development, so birth to 9 months, 10 months to 12 months, or whatever the stages were. I'll just kind of show you what it looks like. So this is what it looks like in the bullet point version. And then if you go down a bit further where everything's crossed off, that was, I think, what Pam drafted. So do you like it in the bullet point or do you like it in the prose version?
What page are we looking at?
You don't have it.
You don't have it.
It's just
I'm
whether
gonna pass it
okay,
around.
you're going to look at it as.
Yeah, so actually what I'm going to do is I'm going to pass it around. If you could just put your last name and just say bullet points or prose as we pass it around.
And don't look at the content so much as just the
Format.
because we'll revise the content. So should we start with the,
Maybe Molly's.
yeah. So we're on the green sheet. Everybody got that? So what Molly has proposed that we add is the underlying sentence under legal notice.
But I'm also flexible. I indicated too, if there's a better way to word all that.
So probably the initial question is, do we want to include something like this? And then if so, what's the language going to look like? Sharon?
The sentence says, "This guide is not intended to address custody or parental rights." I think that means that the rest of that underlying language is unnecessary.
Other thoughts?
The first sentence says the guide does not supersede federal or state law, and I think that is sufficient to say, so it's not necessary to add in a statement of the law then. It just, I think we're not intending to do that, and so I don't think it's important to have that language.
I don't think there should be any reference to constitutional law in this document for a couple of reasons. First of all, I know all the cases that Molly has cited. I do a lot of third-party custody and family formation issues, and that's where the constitutional issues enter into family law. And what we're talking about in this guide is parenting time, presumably between two legally recognized parents, not whether that parent is a legally recognized parent. That is presumed already because they're in a parenting time dispute. So the Constitution has no applicability in these cases. The cases that you cited in here deal with situations where a father has not been adjudicated and he wants to have parentage established.
Pardon me, I can't hear you. I'm sorry, I have a hearing impairment.
The cases that you cited here deal with really two circumstances. One is a father typically who has not been adjudicated as a father, and he wants those rights established. That's different than a legally recognized parent who is fighting for parenting time against the other legally recognized parent. We see constitutional issues come up in third-party custody cases, where it's a third party coming in wanting to take away parenting time. That's what Troxel is about. It was a grandparent. It had nothing to do with the dispute between the mother and the father about parenting time. We're not dealing with custody in this matter. And even if we were, custody is not covered in a custody dispute between two legally recognized parents. There is no constitutional dimension to that.
So are you saying there's no constitutional protections in family court that any parent
In
can
this
rely on?
context, there is not. In a dispute between two legally recognized parents, there is not. It is not. I would challenge you to find a case that says, in a dispute between two legally recognized parents, that the court is going to look at constitutional rights of either of those parties. They're
So
not.
my question, so they won't be, so a parent cannot, it sounds like you're telling me, then I guess if we just need to clarify this, that would be an important next step. What I hear you saying is that in family court, there are no protections. No parent can rely on any protections of that fundamental right.
Not the Constitution doesn't protect them in that dispute.
Constitutionally protected fundamental right. There's
Right.
no protections in place for that right.
The
in
only
family
place
court.
that I see constitutional issues arise in a family court matter is a third-party custody or third-party parenting time. That Suhu case that you cite is an example. That was two women where one of them had not been adjudicated as having parentage status. They were in a relationship, and that's why there were some constitutional issues discussed there. The whole line of cases going back to Stanley versus Illinois deal with the old bastardy laws that we used to have, where a child born out of wedlock, that biological father had no parentage status unless he went to court, got parentage established. And some of those cases deal with a birth mother trying to place a child for adoption without involving the birth father. Well, if the birth father has a constitutional right to try to establish parentage, but that's not what we're talking about in this set of rules. We're looking at disputes between two legally recognized parents. They can be a same-sex couple even, as long as they both have parentage status, legal parentage status. And legal parentage status is either a birth certificate is proof of that if the child is born during a marriage, or you get a parentage order. Now, there may be constitutional issues again in establishing parentage, but that is not what this guideline is designed to deal with.
my hope was that there would be some protections in place because the law has repeatedly said that, and it's here again, a parent's right to make decisions concerning the care, custody, and control of his children is a protected fundamental right. And I think the care and control has something to do with parenting time, but you're saying.
It isn't right.
You're saying A, it does not, and you're saying B, that the right, the constitutional protected fundamental right is only there to establish the right, but there are no protectable interests, there's no protectable, no protections at all for any subsequent care, custody, and control.
I thought Gary was saying the opposite.
Yeah,
which is that
Molly's
it's
not
presumed-
understanding the
It's
nuances.
presumed that they have rights in family
Right.
court
Well,
once
That
they're
language
legal
that you're
parents.
citing, Molly,
Well, can
is
we write
from
that here?
Troxel, and that flows from cases going back to the 1920s, where the U.S. Supreme Court established a fundamental right to parentage. But again, those cases from the 20s were the state coming in saying, here's how you educate your child. There's a famous Wisconsin case with the Amish. But Troxel was a grandparent coming in challenging a parent, a legal parent, say, I want to have visitation with my grandchild. And the biological court said, no, I want to give you grandparent visitation time. And there, the court said that parent has a fundamental constitutional right to keep a third party from overriding their parental rights. But that's not the same issue between the two parents, the two legal parents.
So help me understand the issue between the parents then. First of all, I mean, I'm okay changing this language. If you want to say what you just said here, I'm okay. I would be happy to replace this with what you just said, that it is presumed in family court despite divorce or never married.
That's
It's
legal
however you want to word
advice.
that, it's presumed that they have.
That's
Legal
legal
advice.
information.
So we just said we're not giving legal advice.
So
You know-
It's a non-issue. Both parents have a fundamental right to parent. All of the cases that you cited did not deal with the issues that we're talking about here. I've got the cases right here. The top two, I think, was Troxel and then Suhu versus Johnson. These are people who wanted to come in and take time from a parent. And the court said, you don't get to do that. In Washington, it was because any person can do that. In Minnesota, we have a statute that says a de facto, or I think 2 years. So that's what Suhu dealt with. And this came up months ago at an earlier discussion when you asked about constitutional issues coming up in family court. They don't come because those parents come in as parents. They have a fundamental right to parent like they have a fundamental right to breathe. And if the state is going to do anything to infringe on fundamental rights, the state has to do that under constitutional statutes. So the best interest factors, when you analyze them, to some degree, yes, the court will then infringe upon a parent's right to parent by saying, mom only gets parenting time every other weekend. But it's the state and the courts have this in patriae interest, which means that sometimes when parents can't make decisions, the courts are supposed to step in and make decisions that are in the best interest of children. So I think I've just combined a couple of legal concepts in here, but it's real clear that the people who are at this table who have legal experience and legal training understand 100% that all parents have fundamental rights. It's just under certain occasions the state can step in and do something about those fundamental rights. So again, it's an unnecessary piece of information that I think will only serve to confuse people because it's real clear there's some confusion here.
To try to clarify, so you're saying that the fundamental right of the parents exists?
Yeah, it's a given.
But the courts leave it to the states to decide how, when you have equal competing interests to those rights, that's what ends up in the state courts to sort out
Yep.
how those are going to balance,
Right.
how those are going to be balanced out.
Exactly. Because you can't cut the child in half. So you have to determine where is this child going to be? Is it going to be 50-50? Is it going to be whatever? And then the court, when the parties can't agree, has to make findings that follow the statute. If the court doesn't make the findings, an appellate court will send it back to the court with a reminder, as they sometimes do, you've got to make findings, you've got to address these factors. And so if the court properly addresses those factors, and there's evidence to support the court's decision and analysis of those factors, the court's decision then does have the ability to, it doesn't take away fundamental rights, but it does take away the, there will be some decisions that will impact those fundamental rights. Like, for example, if a parent doesn't believe in immunizations and another parent does, the court has the right to decide if and who is going to provide those immunizations to a child. Immunizations. People will say that violates a fundamental right. Well, somebody's got to be the tiebreaker in that place and in that situation. The Constitution of Minnesota, the statutes of Minnesota, the laws of Minnesota allow the court to determine who will make that decision.
I think we all know there needs to be very little evidence or very little information in the findings of a court order.
Disagree totally.
When a parent's time is restricted and then
Totally
it goes to court
disagree,
and it
Molly.
just says the district court was in the best decision. So my fear is, my underlying fear in all of this is that unless there's some clarity regarding this, that, which I've said multiple times, meeting after meeting, my fear is that we will start to see in the findings of these court orders that we're going to restrict a parent's time because, let me see, on page 47, it says that if you don't have the exact same sleeping schedule for the rest of their life, or whatever it is, I know that's an exaggeration, but whatever it is, for whatever it is, if the parents, whatever reason you want to pull out of here, that's a reason to restrict time. And
Totally
based on
disagree
what
with
you're
you.
saying, I hear you saying that, am I understanding you clearly that you do not believe that restricting time is an infringement on?
Oh, I'm saying it
parents
can be,
at
it
all?
can be. In fact, there's statutes that permit me, and in fact, some of them basically say I should because that parent has committed domestic violence, that
Sure.
parent, yeah, so there, I can restrict a fundamental right.
There are limits.
Yes.
But I guess I'm asking for clarity, what are those limitations?
In fact, each
Is
case
this
is
whole
different.
book Limitations.
So tell
No.
me how your language would prevent that from happening.
It would-
How would it prevent the court from
It would
saying
at
that
least
this
remind-
child isn't getting enough sleep in this parent's home, so we're gonna have an imbalanced parenting time schedule?
I'm not saying that it would. It would at least put some sort of placeholder in there. Something.
For what?
Something.
Or
that
placeholder for
this-
what?
That at least there is a constitutionally protected fundamental right to the parent-child relationship. And it is protected in family court on some level, because, my goodness,
When Judge Hall restricts parenting time because of domestic abuse or parenting practices that are harmful to child development, she's not saying this person doesn't have a fundamental right. She's saying that I need to look out for the best interests of the child. So I understand your very, very intensely held belief that this is necessary. I'd like to get a sense of the room for where people are
I want
at.
some clarity on that first, Mindy. So is this group, you were pointing it particularly to Judge Hall, but...
I spoke fast.
Does it go to the group that the best interests of the child factors supersede any
No,
constitutionally protected fundamental right?
no.
The discussion.
No. Molly?
And why is, I guess, maybe I need to understand, why do you think that needs to be dealt with in this guide?
I keep saying over and over, my fear is that these are going to be, I've said it every single meeting, I think, my fear is that this is going to be 62 pages of reasons for the most
We're not here to decide what
simple little thing
the
that's
law
going to
is. In
restrict.
fact, we're specifically saying that we are not telling you what the law is.
But they use this. Everybody uses this. The courts use this. The lawyers will use this. The custody evaluators use
That
this.
Molly's concern, just to try to clarify it further, is that there's so much minutia that we see in custody evaluations and in judicial decisions about the care of the child and how that affects the parenting time decisions, that this booklet now becomes a whole nother, an expansion of that, if you will. And it's concerning to her, and I get that.
And it's going to be so many, it's going to broaden the scope on what people can litigate. It's going to increase litigation, just, I can't even imagine how much.
Totally disagree.
The
The original guide never increased litigation. In fact, it went a long way to resolve litigation, because people had a tool. I was on the committee that wrote that original one, and I was surprised how many lawyers and parties never even knew it existed. But when they'd come in for a pretrial and they were still far apart, I'd say, have you considered this guide? Well, I never heard about it. Well, we'll make copies for you, take a look at it. And it did help settle cases. It provided information to them that they hadn't picked up in a parent education program. People found it helpful. It never increased litigation. In fact, it substantially helped resolve litigation.
Right, because basically what it said is dads are restricted access. And
Never
the
said that.
schedules are, I mean.
Never
the other
said that,
parent-
Molly. Tell me where in
was
that
the
guide it
outcome.
said.
So fathers just gave up.
Totally disagree.
Ann, you had a comment?
Well, we've
you make?
agreed that it was
Molly,
outdated.
just a second.
Yes.
It was printed.
Let's let Ann.
I'm just concerned, Molly, that based on your comment, I don't think you're giving judicial officers and lawyers sort of the credit that they're able to take cases on a fact, case-by-case basis. So you say, I'm concerned that a judicial officer is going to open that up. I mean, I don't think that's fair to judicial officers. I think daily they're asked to listen to the facts that come in. Lawyers are asked to do the same thing. And I think this is in addition to the statutes that we have, but I don't think it's fair to say that unless we have this constitutionally protected language in, that judicial officers are going to look at that and not make the requisite findings. I guess I view it as an additional tool to, as Sharon said, to give additional information, but I don't think it's going to be this blanket restrictive guide that your concerns are. I mean, if judicial officers don't make the requisite findings, then it'll get sent back on appeal.
And we know what happens on appeal. Most people can't even afford it, and we know what happens. They go right back to the district court and say, sorry, they're in the best position to do this. And I'm sure the judges here are awesome judges. I wish I could be in front, my constituents could be in front of you every day. You're probably different than
I'm glad they're
everyone
not.
else. But
We don't
I
want
see
people in
many
court.
cases that judges don't even know that the 25% minimum is in law. Judges aren't even applying some of the new best interest criteria statutes, and I could go on and on and on. So no, I don't have confidence in the judiciary that they're going to be able to make findings appropriate that are protecting that parent relationship.
I just want to add in, and
We're
part
following
of where
along.
Molly's coming from is that there was substantial work done through the legislature on family law a couple of years ago. Things to remove bias towards sole custody that existed in the law, commentary around the best interest criteria that talks about a parent's ability to raise a child. Quite a lot of changes, and her fear is, and I see that and I get that, is that while those changes in law move toward clarifying those issues and bringing forward progress in terms of parenting time for especially for dads that has been problematic in the past. She's concerned that this guidebook now is going to take away from that, distract from that, move away from the expected outcome of that work.
So as another non-legal person, these are things I've looked at for many, many years too. And when you're missing the point that it is the two parents against each other, it isn't where someone's sitting at home having a great time with their children and somebody, a judge or somebody comes to your door and says, I'm taking your child. It is the parents have raised an issue generally. This system is a process, and right now parents are given so much leeway to work this out for themselves. So it is when the parents don't work it out or you know, they just are really far apart, that family court comes into play. It doesn't
last
happen
resort.
immediately. You don't go before the judge and the judge says, you're going to get the child and you're not, or, so you have to look at it, say both of the parents want every weekend. How is that going to work? That's not going to work, and they're not going to move, neither one of them going to move from that position. That's when we've made the family court there to resolve the dispute. That's what they're there for. Parents have that right from the beginning to start working on this. Now, someone who doesn't have parentage established is different, but how would you make it so that, even a 50-50 split from the beginning doesn't resolve these problems where parents have to be able to make that work 50-50, So how would you just, and the way I started looking at it, Molly, is there are legal processes where it's the state versus a person, but family court is this parent versus this parent. So those have to get distributed, and it isn't always 50-50 because it doesn't always work that way. And there are parents who don't want exact 50-50.
I'm not saying that 50-50 time is the same thing as equally protecting the individual fundamental right of each parent. And I understand that there are logistics, I understand there are exceptions, I understand that there are times when the parents' patriot powers do kick in, but they don't kick in just because there's a conflict. I have not seen any case law that says that is true. I'd like to see that if it is. Well, I guess maybe I would change my statement here then to say, if this is the agreement of the group, to tell parents, you give up your constitutionally protected individual right.
They don't.
That's not true either.
If you don't agree.
No,
They don't.
But how are you protecting it? I guess you're saying that taking away time is not impeding on that right to the care, custody, and control of the child at all. That's what I see happening.
It isn't in family court. They're deciding a dispute and need to be neutral.
But there has
They're
to be
not going to
some
help
things
this
that are-
one or this one against the other.
So bottom line, what's protected?
Your standing to be in court is protected as a parent.
Yeah, and you remain a parent.
No
That is,
protections whatsoever except the best interest criteria.
No.
I think
Kristen?
I think it's important to understand, again, there are constitutional rights and there are statutory rights. They're not the same thing.
Right, which is why I
And the
wanted
cons-
this,
but-
because you were talking about state law, which I thought was statutory in the
But
first sentence.
again, in disputes between legal parents, it's statutory rights that are at stake, not the constitutional rights. Constitutional rights come into play if the state comes in to take your child away in a child protection proceeding, if a third party comes in to try to force parenting time or to take custody of your child. But in a legal dispute in family court between two legally recognized parents, it's the statutory rights, it's the best interest factors that the court is to apply. It's not a constitutional right. And I think that's what troubles me, because I don't think we should be referencing the Constitution here. People have constitutional rights, but they are not in play in these kinds of disputes that we're dealing with this manual.
Because you're saying then that the best interest criteria supersede any right
It's
to
not a
care,
question of
custody, and
superseding.
control of your child
It's a
under
question
two-fifth parents.
of not applying in that situation. You've got statutory rights, you've got constitutional rights.
So if it doesn't apply, then you don't have it, or how?
No.
I don't understand.
you would have it in another context. You may have it in juvenile court if there's a termination of parental rights proceeding, you still have your constitutional rights. But you don't have it in, well, you have it, but it's not at
it's not
play,
the
as Gary
issue.
said.
It's
not
just
at
not
issue.
in.
The court's
Family
not
court.
asked to
Why
It's
is
a
decide it.
dispute between two parents.
Why is it not at play if the definition of it is that you have that right to the care, custody, and control?
Because
of the child? Why is
every
it not at
issue
play?
that comes before a court is not a constitutional issue. They're very specialized
What
types
if
of
it was?
disputes.
What if somebody brought up a constitutional issue in
Well,
family court, then what?
I'm
Both
assuming that
parents have the same constitutional
Yeah.
rights in family court.
Right.
It doesn't get you anywhere to argue your client's constitutional right in family court.
The parent will say,
The
yeah,
other
we-
parent also has the same
But they're not
constitutional
protected, what I
rights.
hear, but
They're not-
the time is not protected, I guess that's what you're telling me, the
The
parenting
time is not
is not
protected.
protected.
Yeah,
Yes.
right.
Without
That's
the
Right.
correct. Kristen, did you want to say something?
Well, I think that answered my question. I got here late, sorry. I didn't know how you were defining restricted, so it was unclear to me when you talk about, constitutional rights and, parents' rights so that their time isn't restricted. I just didn't know how you were defining restricted. So I didn't know if I missed that piece.
So are we clear that parenting time is not a constitutional right?
I'm not clear and I don't agree on that, but it appears that that's the vote of the group. I agree.
Well, I'm very concerned that this is, by putting it that way, it's going to be out there and very misconstrued.
Very important point, thank you.
Yes.
Molly, it's not a vote, it's just what the law is. Constitutional rights would come into play in a child protection case because the state is coming in to perhaps take away your rights as a parent.
Your
forever.
fundamental right to be a parent, yes.
But in a family court case, nobody's looking at taking away anybody's right. That right's there. They're just trying to decide what the custody is going to be, things like that.
What's the schedule?
Yeah.
Custody, right?
Yeah,
this-
No,
this-
not always, not
About
always.
custody. Guys, custody, this
This
guy is
doesn't talk about
specifically
custody.
not about custody.
Right, which is why I left out custody when I said it earlier and just said care and control.
And the guide is about allocating parenting time. Like the judge said, we cannot cut the child in half.
Well,
And
there-
give half the child to each parent so they can have it 100% of the time.
There's
You have
these-
to allocate the parenting time between these two parents.
Well,
A part of Molly's heartburn here is, you brought up child protection. She's seen situations, I haven't seen them, but I believe they exist, where parents' rights, where parenting time is better tended to in child protection cases than it is even in child custody cases.
Because in family court, yes, that hits the nail on the
This
head.
guy isn't
That
intended
is-
for child protection cases.
That's
No.
at the center of
But
some of
in
the
child, this has been a concern of mine for 18 years. You go into child protection court and you have cut the arm off of your kid, then you get put on a case plan, and then you do this and this and this in 6 months, we'll check in, you do this and this, and you might get your kid back. You do this and this and this in 12 months, and you probably will get your child
No,
back.
you cut your
Even though
kids
you have
off.
totally hurt your child, and there's a whole other list of reasons why that can be done. But in family court, you've done nothing wrong. The worst thing that they can pin on you is maybe you went to 6 of the doctor appointments instead of half, which was 7. I mean, some of the things I see are ridiculous, or you got a cat, or you didn't get a cat. There's all kinds of reasons that parenting time, and even custody too, but we're not getting into that, is being restricted. And there is no way, virtually no way, for the parents to get that back again, which goes back to why I don't have confidence in the judiciary, why many people don't have confidence in the judiciary, because of, again, the changes that we made in 2015, maybe even 14 in the law, that said that you can reserve time and you can add to it later. That was the intent of it, that you can go back. It was supposed to be easier to go back to increase your parenting time. None of that's happening, virtually.
But
Here's a pocket change here and
Can I go back to my
there.
question? How are you defining restricted? Because you keep using the word restricted, but what do you mean by that? Do you mean a schedule that isn't exactly 50-50? Or do you mean a parent who doesn't get any kind of contact with their child?
I'm worried about the fit, loving, responsible parent that's ready, willing, and able to step up to the plate to equally share in the responsibility of raising that child. And there's absolutely no severe situation whatsoever, and it's logistically possible, and there's no abuse, harm, neglect, or abandonment. There's no untreated mental health, no untreated domestic violence, no untreated mental illness. I would say those differently maybe. And logistically possible, geographically possible,
But what's
all of that.
that-
Why are they restricted in time as much as they are able to, ready, willing, and able, as much as they're ready to?
So if
Take
they're
on
not getting
cause.
50/50, then that's a
As
restriction.
much as they're willing and able to take on,
And
excluding all
because-
those exceptions.
Well, what if they're both willing and able to take on 80% of the time?
Then why wouldn't it be 50/50?
And because,
Because there might be other facts
Judge
in
Levy?
that particular situation that would compel a different outcome in the best interest of the child.
Work schedules, and there's so many
If I might say
things.
something here, I haven't said anything yet. The first thing I think it's important to understand is, child protection cases versus family court cases are measured by a completely different yardstick. And so it's not apples and apples in the sense that, like when you look at a criminal case, the standard of proof is beyond a reasonable doubt. In most other cases, it's proof by a preponderance of the evidence. So that's a different yardstick. The case between family court and juvenile protection, you're talking about, the parent that's done something terrible, they are given 6 months to try to fix this, and it's a different yardstick there, and that the law is presumably trying to reunite the family, fix the problems that led to that. So you're looking at you're using a different standard, you're measuring it differently when you're comparing the two parents. And what you're talking about here, completely legitimate, you have two parents that are, ready, willing, and able to parent this child, both want 80%, why should they not have 50%? Now the yardstick has to be the best interest of the child. Is there something about the child that would lead us to believe that for some reason that 50-50 might not be best for that child? It might be best for either parent, but is it best for that child? You have to look at the facts of each individual case before you know that. But my whole issue is, what yardstick are we using to measure this by? And so what you're saying is not wrong. It's just we are in family court supposed to be basing it on this particular child more so than these particular parents. So our focus is different. Our yardstick, what we're measuring, looking at, is supposed to be somewhat different.
Judge Robin, did you?
Yeah, I was just going to say, for me, from my point of view, why I would suggest we not have this proposed language in here is because I really keep going back to what is the purpose of this guide. It's not to change the law, it's not to create evidence, it's not to be some opus on what family law is in Minnesota. I go back to, from my point of view, it's really just to tell parents, here's some practical things you should think about when you try to come up with a schedule. Full stop, drop the mic. That's what this is about. And there may be other ways that some of this broader philosophical discussion can be had, or people can be educated about the law, or what people think the law should be, or what they think is happening in courtrooms. But when we go back to what I think is what I understood that this guide is supposed to be about, I think we kind of drift outside of our purpose when we go too far down the path of talking about some of this other stuff.
Well, how do we say in here then that the minutia in this guide, which I know is a, judgmental word we wouldn't want to use, but how do we say that the minutia in this guide is not meant to be litigated over word by word, sentence by sentence, section by section?
Because it's
How do
the
we
title.
say that?
The title and the introductory paragraphs. What I love about this guide, what I found it to be so helpful, because it just continues to frustrate me. I've practiced family law since '85. I've been a judge doing a lot of family law since 1993, and I am still stunned. The number of people who come into court who think, first off, their child gets to pick where they live when they turn 13, that the only parenting time out there is one evening a week and every other weekend. And I know they pick up a lot of that stuff from well-intended family members and friends. We all know that is not the law. They don't know that. This is what gives them information about, hey, never thought about this. hey, this is how old our child is now, so we can do this now and can build in a provision about what we're going to do. We're going to get together again, we're going to mediate, we're going to do whatever when this child turns 6. I mean, it educates them to options that they never even knew existed. That's what this is intended to do, is to educate. Give them more information. Be a guide. It will never be a rule. It will never be a rule book. I can assure you from my 24 years on the bench, no colleague has ever looked at this as the law. It is a guide. Just like the child support guidelines years ago, they were a guide. You could deviate from them, but you didn't have to follow them. They were a guide. This is a guide, again, with the goal to educate and help parents exercise their fundamental rights to parent their children in a manner that they can both agree with. We only come into play when they can't agree, and then we may have to make a really difficult decision. And I know, Molly, you think that we do a lousy job at it, that we don't know what we're doing, that we're biased, we're prejudiced. You know, I've never seen you cite a case as a horrible example of how that all went wrong. I'm proud of my colleagues for the hard work that they do. They want to get all the education they can on family law. There is a bit of a disadvantage, I will concede, when a judge comes to the bench who has not practiced family law. This is a complicated area of law, very complicated. But I can assure you they try to do their best.
Just one last comment from me. What is at the heart of our struggle is that we know there's so many fathers who don't step up.
And they need to.
And when they do step up and they're fit, loving parents, the results we see them have in family court in terms of the child's time with them.
Again, refer me. I'd be happy to look at that case. I can't tell you whether the judge did a good job or a bad job.
And she should refer those to you.
And they're scared to death. These fathers are scared to death for their needs to be exposed because they are certain that it will get back and haunt them for any other future proceedings.
It's already public. It's already out there.
Can I just make one point too? I will say that I've talked to parents who say they took my rights away, they didn't give me custody, and it turns out a lot of times that they agreed to this schedule and this custody arrangement, and it is hard to change once you've agreed. So people need to really look at who did it to you. Was it you? Was it a judge? I mean, it is common for parents to perceive someone has done something to them when in fact they created their own prison.
But they also don't understand what's going on in those E&Es or other places like that. That agreement means they never get a disclosure that says,
I do agree
you
with
make
you
a
there.
decision today and you are pretty much locked into this forever. It's going to be really difficult to change this. They don't get fair warning like that.
This guide is not about that. It has nothing to do with E&Es.
Well, let's get back to the guide then, Mindy.
So,
but I take that back because the E&E people will use this. I think we list them as people that will use this guide, don't we?
Not for custody, but for establishment.
For parenting time.
Mindy, may I just, so I think, Molly, no one disagrees with you that the cases you cite are good law. I think the issue is where do you have to make this pitch? And I can tell you, I've used these cases recently in a number of different guardianship cases. So when a child turns 18, needs legal guardianship established, oftentimes people propose a third party who's not related to the child. And I've been able to use, and I invite you to join me, use the Troxing line of cases to argue that an appointment of someone other than the parents would infringe upon the fundamental right of that parent to parent their adult disabled child, and been very successful. So I think the issue for me is not, is Molly right or wrong? I think you're right. I think that we do need to protect that fundamental parent-child relationship. The litigation where I see it happening is in guardianship court and not necessarily in family court right now. I don't know if that helps. I'm trying to give you some context as to where this litigation is actually taking place.
I understand that, but it seems absurd. I guess, isn't it said somewhere that if the law seems absurd, then it needs to be reconsidered. It seems pretty absurd that parents have more rights in child protection. Their time with their child are protected more in child protection court as a matter of procedure than they are in family court, and that each parent is not individually protected with their time in family court at all. That's absurd to me. It's
It would be
concerning.
absurd if it were true.
Yeah.
I don't think that's true in my experience.
And you,
It would be absurd.
yeah, you cite an example of a child whose parent cut his arm off. That child, they wouldn't be doing reunification there, and that parent would be having supervised parenting time. That person would be in jail and on their way to prison. If anything, there might be a termination of parental rights.
I'd like us not to argue about what happens in child protection.
Thank you, thank you. Good, thank you. You're absolutely right, Mindy.
I like what Judge Robin had to say with respect to this guide. Is titled Child Focused Parenting Time Guide. And so when we get into parents' fundamental rights, it kind of deviates from the point of the guide, which is child-focused parenting time, not parents' rights to parenting time with their children, but this is about kids and what's going to serve their best interests. And in many cases, it may be 50-50 parenting time, and in other cases, it may not be. But to focus on the concept that a parent's time is restricted because they don't have 50-50, I think is not a healthy way of looking at things, because there are parents who don't, and it makes sense for them, and it makes sense for their kids, and they still can have a relationship. I mean, we're talking about relationship with your children. You can have that in a variety of different capacities. It doesn't have to be equal time in order for a child to have a relationship with that person.
Kristen, it's hard for me to hear that, and it's hard for dads, fit-loving, responsible dads that are ready, willing, and able to step up to the plate to share equaling the responsibility of raising their kids who've done nothing wrong in the whole litany of exceptions I've mentioned before. It does not ring well to their ears when you say the time doesn't matter. I guess if you were in those shoes and you only got to see your kids 25% of the time, you might have a different view on that.
Right, and I understand that, and I'm not saying that view is invalid, but what I'm saying is that's not what this guide is about. This guide is about children's interests, not the parents' interests.
And the research says, which we're not looking at the research, are we? The research says that children do best when they maximize the time with both parents, and that's how somehow we got some maximized language in the statute in the best interest criteria.
Right, and again, I don't think anybody's arguing that parents, that 50-50 is not something that should be considered. I don't see anywhere in this guide where it says that shouldn't be considered.
But the priority right now is to limit the access, not to maximize the time. That was
So wrong, Molly.
Not in this guide.
No.
Not in this guide.
How do we say that in there then, Mindy? How do we say that in here?
Well,
Because
first
we're
of all,
not
this
saying
isn't
anything
prescriptive.
restrictive, so we're neither saying parents should have 50-50 or parents shouldn't have 50-50. We're saying from the perspective of the child and your parenting situation, here are some things you might want to consider.
And I'm not always saying 50-50 parenting time. I'm saying maximizing according to what's
And that's what we've
logistically
got in
possible.
I don't
So
think
can-
we have the word maximizing in here
Has everybody
anyway.
said what they
No,
want to
because
say
you
on this
said we
topic?
weren't going to use that word and we weren't going to define that in any way.
Use what-
But let me point out what we did say.
Right.
We do say, we just need to figure out where it goes, these 3 points. Children do best when parents support the relationship. They do best when both parents have parenting time. Those concepts will be in here, we just have to figure out where. We're not saying anything about custody, that it's 50-50. That's not the purpose of this guide.
Right, but, I mean, these sort of vague statements have been used forever, and, you know, to a lot of people, supporting that relationship is less than 25% time even. So, anyway, I think we're done for now, probably. But go ahead, yeah.
I just had one comment, and I see this in my practice. I think parents, I keep hearing 50-50, 50-50, 50-50. Number one, I don't know how we calculate 50-50. And number two, when I talk with parents a lot, I encourage them to not get hung up on the percentages, because if we don't know how to calculate them. The default is overnights, but parents see their children a lot of other times, and so when you keep focusing on the 50-50, I think that's a misnomer about the actual amount of time the children are going to spend with parents once parents are in separate homes. I did an analysis for a client once because his overnights were not 50-50, but we actually sat down and calculated out the number of FaceTime hours that this dad was going to have with his children, and because he didn't work on Fridays and because of the parenting time was heavily focused on the weekend, he actually had 80% of the FaceTime parenting time with children. And so I'm just encouraging you to kind of think outside the box and not get hung up on this 50-50, because parents have quality time and a lot of quality time with their kids in other ways other than just where they rest their head at night. And I keep hearing the 50-50 from you, and I'm just encouraging you to think about parents having a lot of quality time with their children in ways that aren't just the overnights.
Well, first of all, I think most people here are using 50-50 more than I am, because I keep going back to that one phrase that I've said repeatedly. But the other thing about 50-50 that becomes very disturbing to me is that people have started to label any dad or any kid that asks for 50-50, they're labeled like they are fighting for something unreasonable. And to me, that is absurd. If you want to step up to share equally in the responsibility of raising your child, that you would think that's equal. I even, within the last month, saw a brand new custody evaluation from somebody that said the child in this case asked 50-50. No child would ever ask for 50-50 unless the dad had programmed him to ask for it. Which is, to me, that is like, do you know how offensive that is? Sharing is one of the very first lessons that parents teach their kids. Sharing is all about 50-50. Kids understand that at a very early age.
But that's a custody evaluation which makes recommendations.
And the custody
And
evaluators
then
will
a
be
parent
using
has
this.
the right to challenge that.
And
correct?
how often does that really work?
Well, yeah, but they have that right. So you're talking about rights. And a lot of times,
I'm talking
again,
about protections. I'm more concerned about protections.
and they do have that. I mean, if that was really, a parent really said that is absolutely wrong, not true, I'll prove it in court. That you have that right. It's hard to prove things like this. That's part of the problem. It's hard to prove in a he says, she said, or what happened inside the privacy of somebody's home. And that is why this is so complicated.
But this again is not a guide about protecting parents' rights. This is a guide about making parenting time decisions. It's an educational tool, which is why we're not doing anything prescriptive in it. So again, I want to take the focus back to kids and away from parents. Parents' rights are important, and that's important to have those conversations, but that's not the intention of this guide. That's a different forum. This guide is supposed to be about kids and helping parents come up with plans that are going to make sense for their situation and their children, which could be 50-50, could be 80-20, I'm bad at math. And it could be that they're 80% with dad and 20% with mom. I mean, who knows? And that's why this isn't prescriptive. That's why we're not doing it that way. We're saying, here's information, use this as it makes sense for your family, and then move forward and make decisions that are going to meet your kids' needs. I mean, that's what this is about. It's not about the parents' rights. And again, not to diminish parents' rights, but that's not what the focus of this guide is about.
And
So
Molly?
What I'm hearing is that I certainly understand the concerns that you've expressed, but I'm hearing that the group doesn't necessarily think that they belong in this particular guide, but maybe are arguments to be made to the court. Fair? And so I'm hearing that the group is thinking that it would be best to leave them all, leave that statement, the right statement of this particular guide and keep it child focused.
The reason Molly fights so hard for this right now is because there's no clear avenue to bring it forward otherwise.
Well, and I don't know that this
We
guide is the
really-
place for that particular argument to be hanging its hat. We're expressly stating that we are not making any comment about.
Yep,
in the
no,
right
I
circle.
hear you on that. I'm just, I would ask the group that, to consider that concern and what might be, what other avenue might be available to address some of this.
And that might be a topic of a
Just
private conversation.
either individually or whatever, but that would be greatly appreciated.
All right, so we move on to this one.
Back to the chair.
All right, so then we're back to
Page 15.
Page 15 of